liable to serve on juries. You'll see certain exceptions, one of which is in 2B, sub 2B, cannot speak, read, and write English. And others, D, for instance, you've been convicted of treason or another serious offence, then you're not qualified. And then subsection 5, save as provided by or pursuant to this section, but subject to section 18, no person qualified to serve shall be exempt from jury service. And then section 6, no person whose name is on the jury list, I'll come to that in a moment, as a juror shall be entitled to be excused from attendance at court on the ground of any disqualification or exemption other than illness not claimed by him at and before final settlement of the list. But a judge, registrar of the Supreme Court and so forth may excuse any person if satisfied that the person is disqualified or entitled to exemption, hardship in the case of employment, or such person for reasons which would be sufficient to the judge and so forth should be excused. And that's why I say this is essentially a public duty. Then section 7, you have the provision as to how jury lists are made up. I don't propose to read that out, but there's a provision for making up of jury lists. And section 8 gives further details as to how the jury list is to be drawn up, essentially by justices. And then section 10, it shall be lawful for the justices at such sessions to strike out of such lists the names of all persons shown to their satisfaction to be not qualified or not liable to serve on juries, or to be dead or disabled by mental capacity, deafness, blindness, or other permanent infirmity. So this is the way, as it were, you are removed from a list. And then B, to add to such lists the names of any other person, and then C, to correct errors. And then moving over to section 13, where the list has been settled, the justices shall certify that the list is, to the best of their knowledge, a true and proper list, and so forth. And that is the list which is to be used, from which juries are subsequently selected. One then goes to, I think, provisions we already have, section 31, on trials on indictment for treason or murder, committed in certain circumstances, and that's essentially capital murder. 12 jurors shall form the array on trials on indictment for the circuit court other than an offence of 1, 7 shall form the array. And then 3, where...
Can I ask, is ours a murder falling within either of those two categories?
No, I don't think it is, because it's, I think, just dropping down, it is in, well, it's 44, section 44, I have a feeling.
Yes, well, if that is with review to section 44, yes. I was asking the question.
Yes, yes. We're in section 44.
Would we have been in 31 1B, but for the discharge of one juror, or is it not a murder within?
I have a feeling, I can double check this. In Jamaica, they've got a capital. They essentially have capital murder.
Yes.
So killing a policeman, the execution is duty, and for that you need 12. That's what I understand.
I see.
Can't go for 12 for that, but we're not in that category. So 31, 12 jurors shall form the array, and then subsection 3. When in the course of a criminal trial, any member of the jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as, I would imagine I emphasize, the number of its members is not reduced by more than one, be considered as remaining properly constituted for all the purposes of the trial, and the trial shall proceed and a verdict may be given accordingly. And then subsection 4, where one juror has died and been discharged, the verdict of 11 jurors in a trial for treason or murder referred to in 1B, or of 6 jurors otherwise, shall be deemed to be unanimous verdict. So
and so ours would be within the ambit of the provision about 6 jurors.
I don't think we're down to 6 jurors there.
Well, we're not in the... You just told us ours isn't a trial for treason or murder referred to in subsection 1B.
If I can just double check, that's my understanding. Certainly my understanding is that it may be, if I can double check this, it may be we are in fact in 31, so that you can go down to 11 That certainly seems to be the assumption on which everyone proceeded.
Well, I don't know if they did, because when you get to 44,
Yes.
I think the implication of 44 is that you need a unanimous verdict to convict of a murder falling within the categories described in 31 1B.
Can I just take instructions from those behind me, because that explains it. What we're looking at here is, if you look at section 31, it's an amendment made in 2015.
Yep.
That is why there's confusion. I do apologise. The proper 2010 Juries Act is already in the bundle. In other words, what I produced today in this section is a 2015 amendment, which I think, which would post-date the trial.
Can you show us in the 2010 version?
Yes, that would be, I think, I think I'm right in saying volume 1. I hope I'm right in saying volume 1 of the.
Yeah, we've got section 31, but we don't have section 44. It's the version we've got in bundle number 11 on is again the 2015 as amended in 2015. That's page 6803.
I do apologise.
I appreciate you don't bear sole responsibility for this, Mr. Knox, by any means, but it's quite important that we actually have the legislation that was enforced at the time of the trial.
My Lord, absolutely. My Lord, can I say one of the difficulties, this wasn't the point, of course, that was raised in the defence grounds and so forth. So it has been a bit of a rush, and I do apologise.
We don't need to be rushed. We can adjourn for some minutes if that's going to give you time to get hold of a copy of the correct version of the Jury Act.
As enforced at that time. It's not always that easy from my experience. One has to dig back a bit. But can I just say this, certainly for the time being, the point I'm making, I'm assuming, as everyone has assumed, that a jury of 11 was a sufficient number, but it couldn't go below 11. That appears to be common ground throughout the trial, and of the appeals, understand it. So that's the premise. You can't go below 11. The point I'm on, one sense, is not whether or not you go below 11, but what is the nature of a jury? And the nature of a jury, in my submission, is simply there are 11 members on it. And if there are 11 members on it, you've got a quorum. Even if, some reason, one or other of the juries is not is acting improperly, or there's reasons to place he's acting improperly, as long as he's on the jury, he is one of their number. And it's only when he is discharged that the jury number is reduced. That is the point I'm seeking to make, my lords. And I do accept, my lords, that obviously it would be important to get the right version for you, my lords. If we could, I'm not sure we could do it within a matter of minutes, just from experience, but if we could do it as soon as practical, and get over to you the relevant section with, if appropriate, a very short note about what it comes to, that might be a better way of dealing with it. But for the moment, my lords, I'm just making the point. There was a quorum. And the reason I say that is because jury service is a public duty. You can't just get out of it. And once you are in the charge, if I can put it this way, of the jury, it's the jury who has to deal with you until the judge says, until the judge, quote, discharges that particular juror. My lords, I've just received a note saying the Deputy DPP has sent the 2010 Act. I won't proceed it myself, but my lord, perhaps I could just come back to that in a moment, rather than take time trying to find it myself. And my lords, yesterday one of the questions was put, well, what about mental illness? Now, one can see that if someone becomes mentally incapable in the course of the trial, let us say, on day 7, he is simply incapable. Well, my lords, my submission is still strictly on the jury unless and until he is removed. But in circumstances like that, the judge in my submission would have no choice because that juror would be incapable, simply incapable of performing his oath. And there's a difference in my submission between a juror being incapable of performing his oath and a juror who's capable of performing it, but who is, for one reason or another, bent on not doing so. And in the latter case, I submit, he still counts, and the judge is still entitled in principle to say, I'm going to carry on and I'm not going to release you from your oath. So that's the first point I want to make on the quorum. The other point I was asked yesterday, could a court review the decision made by the jury after it is made it to find out whether or not it was in fact, there was in fact, let us say, a crooked juror on it, with a view then to that conviction being set aside. And my lords, my lady, the answer to that is yes, and that's exactly was the issue in a case called Merzer, which is in the bundles at 7490. And that was a case where after the event, one of the jurors, the disgruntled juror who had wanted an acquittal, wrote, I think, to the court, the judge, saying, I'm very unhappy about this, because I think the other jurors were racially motivated to produce conviction. And the matter went up to the Supreme Court. And of course, one question was whether, given the Contempt of Court Act, 1991 in the UK, the court could actually investigate that allegation. They held that they could, on the footing that the Contempt of Court Act wasn't intended to prevent the court from making such inquiries with a view to an appeal. And the common law position was, they held by implication, that of course the court can, with a view to an appeal, make such an investigation if necessary. And on the facts of the case, the Supreme Court held, I think it was the House of Lords held, there was no need. There was no requirement to look into the point. But when we pick the point up, it's at 7490 at paras 9 to 10. That's where the case starts at 7504. And this is in the speech of Lord Stane, 7504. Undoubtedly, there must be a general rule. Deliberations of the jury must remain secret, and they refer to Gregory, the ECHR case, which accepted that. And then, moreover, there's a strong rebuttable presumption that the jury was impartial, and that is how the matter was dealt with there. And they went on at the end, or rather, Lord Stane, I think, speaking of his others, para 32.
We must be a little bit careful with Lord Stane because he dissented.
I have a feeling he may have dissented in the results. I'm not sure if he was dissenting in the...
Yeah, no, I haven't read this for years, so I can't recollect, but so he's a little bit cautious.
Yes. I'm not sure he dissented on this point. But if one looks at the head note, he does... he is, as it were, agreeing that the court can look at the position after the event. that from the head, but I was also taking to the
Where were we going after page 7504?
I was going to give 751 that says 2, where the state says, well, on the wasn't satisfied that the complaint during after the event was given an entirely accurate account, which is paragraph 32.
But as I understand it, you're saying this case would fall within what's called the only exception.
Yes.
11.
Yes.
Yeah.
So the secrecy rule is the prevailing rule, but there can be exceptions. And that's the main holding of I'm just looking at 7490. So, my lord, that's what I say. So it is in theory possible. It would in theory be possible for a juror after the event who's kept, or for it to be discovered after the event that a juror has been bribed, he's kept it to himself, and for the court then to investigate. But in my submission, in those circumstances, the court would still say, even though the juror had been bribed, let us say, the jury was quorate.
Is the ratio of Mirza at paragraph 94 in Lord Hope's speech, page 7527, paragraph 94 onwards, which makes clear there is a prohibition. It's only where, in effect, some extraneous occurrence has occurred that means effectively the jury didn't deliberate. They used a Ouija board or something of that kind.
94, 96, yes. 95. Of course, there's no doubt about the general rule. My lord, that's what I have to say about the quorate point. Was the jury quorate? My answer is yes. The next question is, was the judge bound to discharge the jury in any event? Because the risk of prejudice or bias was irremediable. Should he have said at that point, when the complaint is made, should he have simply said, well, we can't carry on, full stop, because of the risk of prejudice to the defendant. So my submission is no. First, there's the point I made yesterday. It cannot be the case that an accused can engineer the automatic end, I emphasize, automatic end of the trial by his own misbehaviour, tampering with the jury, and likewise, I submit that cannot be the case in the event of a juror who necessarily hasn't been contacted by the defendant, but for whatever reason, he is acting in the interests of the accused and offering bribes. It cannot be the case that a trial be brought to an end so automatically in those circumstances. And in my submission, were there to be such a rule, it's a common law matter, that would bring the system, the whole legal system and the jury system into disrepute and make the administration of the jury trial almost unworkable. Second, on the facts.
Why do you say that? Because in normal circumstances, if this came to light, that particular juror would be discharged.
I agree with that, normally.
So the whole system wouldn't come to a halt.
In circumstances such as this, I agree with that. Because you could discharge a jury, but in circumstances such as this, it would bring automatic. If my learned friend's right, there's an automatic. It just comes to an end. Full stop. I submit that cannot be right. There is still a power in the court, as long as a fair trial can be ensured. There's still a power in the court to allow the trial to go ahead. And in my submission, the next question then is, well, did the judge exercise, or can it be said the judge exercised his discretion wrongly and perversely in allowing the trial to go ahead? That is the correct question, focusing on the position as it was before the trial judge when in my submission, the trial judge, it'd be wrong to interfere with the trial judge's exercise of discretion for the following reasons. First, as things stood, it was a mere allegation, no doubt one which appeared to be supported by strong evidence, but it would not be practical at that point to carry out an investigation of the corrupt juror himself. That couldn't seriously have been done. And what is more, my lord, I might add, although he was found guilty of attempting to pervert the course of justice, he did in fact plead not guilty. And one just wonders, well, what in real life? What benefit would that have done? How could the judge have taken matters further? He had it on the word of the forewoman that she had told the jurors that they weren't to take any notes of this, and in my submission, that was good enough. What was to be gained by the judge asking each and every juror what their position was? Secondly, in my submission, the judge was entitled to take into account the view expressed by the forewoman that none of the 10 jurors had accepted the bribe. That was an important point. He's entitled to take that into account and say that sounds true to me, and that she, the forewoman, had told the others that they must abide by their oath. It's obvious that the judge was impressed by the forewoman, and he would have seen her, and he will have to form a judgment as to whether she's a trustworthy person. And he's entitled, in my section, to take that into account. Third, he was entitled to take into account A, his own directions so far, and I'll come to those in a moment. B, his assessment of the jurors over the 56 days of trial so far. Especially this, my lord, it is evident they had acted on his repeated warnings not to talk to anyone, despite the obvious temptation of doing so in such a high-profile trial. And C, he was entitled to take into account that he could give a further direction that could be given to remedy any prejudice to the accused. Now, I'll come to that direction if I may in a moment, but just before he goes back into court, he's entitled to say to himself, it is proper for me to carry on with this trial, because I can ensure that a fair trial will happen, bearing in mind everything that's happened in the case. Thirdly, I emphasise this point. The Court of Appeal, who have a good knowledge of the local circumstances, upheld the way the judge dealt with that. And that you see at E5869, paragraphs E5869, my lord, yes. 5869, paragraphs 237 to 238. And then also 240 to 241.
The paragraph, the second sentence on page 5869.
Yes.
That approach, on the face of it, looks somewhat problematic. I would suggest that we don't want to investigate much further because the likelihood is we're going to have to discharge the jury.
Well, my lord, one has to see that in context. He's saying, with nothing has been gained and a great deal that we've lost the possibility of having to discharge by questioning the accused juror. So it's not just saying, the court of appeal saying what was to be gained by questioning the accused jury. And in my submission, that was a perfectly proper approach. One does ask, what was to be gained by?
But it's an acknowledgement that that juror was not going to abide by his oath,
Well,
isn't it?
well, it's acknowledgement that he may well not abide by his oath. That is right. I cannot deny that there was obviously a risk, bearing in mind.
Well, more than a risk. It was
A likelihood, maybe, so far as one could tell. One only has an allegation. But I come back to the point I made yesterday.
Well, if it was just a risk, then he would have investigated and impressed upon the juror the importance of not being affected by extraneous considerations.
I can see that. But even if one allows that, you have my submission yesterday. If the risk is just that one, or probability that just that one juror is not going to perform this duty, that in my submission is not a reason for discharging the entire jury if the prosecution, who are affected by that bias, says carry on anyway. And that you might say is a pragmatic point, but in my submission, that is a perfectly proper approach for the court to take. If it is, I mean, it wouldn't be right the other way around. If there was a juror who was biased against the defence, that might well be very different indeed. But here we are talking about the state who is bringing the charge in the public interest, who knows there is a problem with one juror. Because one juror is bent against the prosecution, come what may. Let us assume that the real point of the case is that there was a risk that the whole of the rest of the jury were biased against. Well, I accept that's a different risk, if I may, for the moment. That is a different risk. But just as far as questioning the individual bad juror, and that was the point which this particular paragraph is on, I submit that there was nothing to be gained. There was indeed. What's he going to do? He's just going to deny it.
Yes, but it is really the point I think Lord Burrows was making, that if you read on, they're saying a great deal would have been lost by questioning the accused juror. What would have been lost would have been the trial, because if the accused juror had admitted the conduct alleged, then not only he but the entire jury would have had to be discharged.
Well, my lord, I submit he wouldn't necessarily have discharged the jury, even if, let's say, the individual juror had said, "Oh, I own up. I did try to bribe them." My lords, it all goes back to the single point. There's a different point that Lord Briggs makes, which is about the introduction of the rest of the jury. But there's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly. So I'm sure they're able to do it. But he knows that one is very unlikely to do so. Supposing that is the position. The question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come or may, in my submission, he's entitled to do that.
The answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
But in my submission, if you absolutely must, in all circumstances, even in a case such as this, when you've got right to the end of the trial, you can have a 10-1 verdict, and so forth. If you must, then my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorum verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder. Clearly there's a public interest in a true verdict being returned. the indication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lord, he has to be satisfied that the other 10 won't be nobbled, or is very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad jury here, I've got good reasons to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, is entitled is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that that's the kernel of my submission. And it has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have to.
If it were the case that the same rules applied in Jamaica as applied in England and Wales, that is, you could have had a jury of 10, what would you then say?
My lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balance.
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole
an unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall, I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say, the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was majority or not.
It might be. But in those circumstances, that is a risk that the prosecution.
Well, that's the point. That's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but by law, it is still the responsibility of the court. If the court is satisfied,
but you see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt. For all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
Again, I come back to my point that the judge is entitled to weigh. The judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes. I mean, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this part and everything else is enormous.
But my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict. If there can be, then in my submission, the lesser of two evils is to go ahead and get that fair verdict, rather than simply say, trial off, no verdict, which in real life may well be no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge. It's what is the responsible. Forgive my putting it this way. The responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
A fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
He might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
He may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes. But that is an ongoing risk.
That is my lady. I accept that is an ongoing risk.
Yeah.
That must be right. Is a risk. You will try again.
Yeah.
I mean, you might think it's a bit unlikely if that has been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a fair verdict, that is the lesser of two evils. And if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection. One says, of course, this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is.
But the defendant's counsel didn't accede to this way of proceeding. They continued to raise Well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the court point, but they were objecting because of the way it's put. I think by one of them is the overcompensation point. I'm concerned about it, and that's a fair point. And I'm not saying it's a bad point, but in my submission, it's not a conclusive point. Judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, the strength of the case. I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge in my submission, and this is in a sense the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it. For the reasons I give. And I do submit, I take my lord's point about the court of appeal judgment, but I do submit this is important to bear in mind what the court of appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point that we made again and again. And I do submit great respect should be given to the court of appeal's assessment of this point. Well, it will be. But so, my lord, you have my point on that. Can I? So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstances in which he found himself, and the possibility they could still get that verdict. That's the point. My lord, can I just turn to the judge's directions? But it is important that it ties in with the previous point. I've already given references to some directions before. Can I also ask you to go, please, to E4723, the 4, which is what he says to the jury right at the beginning, which is a resounding direction in my submission. E4723. 4723.
4273 or
4723.
This is right at the start, is it?
Yes, right at the start.
Start of his summing up.
Start with summing up, yes. and it continues to 4724.
And this was at this stage was judge in ignorance of monopoly.
Yes. I don't propose to read that. If you could just read those 2 pages, continuing to the top of 4725. And I should actually ask you to continue to near the foot of 4725, actually. I may. Now, if I can answer the first point you put to me yesterday about more pointed summings up in other cases. If this had followed the incident about the bribing juror, one would say it covers the points. Ignore all prejudice. In particular, each of you, right at the beginning, each of you took an oath or affirmation. You will recall that. This is of great significance. I want you to hold that. The oath is of great significance, not to be treated lightly. The essence of what you swore to or affirmed is that you would decide the case based on the evidence, and then repeatedly he goes on later. He says, I've been boring you all the time about my constant reminders, and well, they're all over the place. I tell you again, because it was of tremendous importance and remains such. Then 4725, I implore you because of the oath you took, serious and responsible function that you have. You cannot bring external considerations. My submission is this. He doesn't repeat this after the incident, but he said it right at the beginning. And in my submission, one has to act on the premise that the jurors haven't forgotten all about this, especially because it's something he's been, he's been banging on about all the time, the importance of the oath and the seriousness of the task they're employed on.
Can you remind me how long the summing up lasted?
I think it begins on the 6th of March. You can see that at 4722.
Ends on the 13th.
Yes, I think there are breaks. I have a feeling it may have been 3 days altogether, but I will be corrected if it's 4 days. I think there may have been, but anyway, we know the gap is ultimately 6th of March to the 13th, I think so. Which is perhaps the more important point. But in my submission, they won't have forgotten all this. Can I also, while I'm on this point, at 4738, a little bit further on, is the point about prejudice. And this, 4738 to 4741, he goes on about prejudice. Ignore all prejudice. Just look at the evidence. Don't speculate. And it goes on to 4741. In 4741, halfway down the page, if I can just ask you again to read that yourselves. Particularly the first half of 4741. Again, I implore you not to allow feelings of sympathy or prejudice to influence you, cause you to ground your verdict. There's no room for a verdict which has its genesis in sympathy or prejudice. Your verdict must be arrived at on the basis of the evidence and on that basis alone. All this is coming quite early on in the summing up, but it's absolutely emphatic. And just while I'm on the summing up, 4769 is where the judge gives his direction, or the first of his directions, 4769 to 4770, to keep separate. That is to say, consider each of these cases separate. It's an important direction in the context of this type of case. Now, in my submission, taken in the round, these directions were good enough to ensure that the 10 jurors at least who returned the verdict of guilty did so uninfluenced by the offer, or by the misconduct, rather, of the bribing jury. They would not, in my submission in the light of this, have said, or been subconsciously influenced against them. These couldn't be firmer. That leads me to my fourth point. Was there, looking at the case as a whole, a real risk that the trial was unfair? A slightly different question, but it's a global question. I say no. First, I say...
Before you go there,
yes, of course.
could I trouble you just to take us to what was said by the judge immediately after the hearing in chambers? You took us to it yesterday, just in terms of page reference.
Forgive me, my lord.
5149.
I'm very grateful.
Yes.
Now,
5149.
5149 Port 30.
Yes, thank you.
This was after the
immediately after
the matter had been raised with the judge.
So the jury come back in, so to speak, after the half hour when they've been kept waiting. And this is the first thing the judge says. And that's why we say it's obvious to the jury what he's referring to, because they will know what has happened in the previous hour.
Are you suggesting that's a targeted direction?
It
It might be said against you. You're just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. And that is true. I fully accept it is not targeted. The question is overall. The overall question is, did the jury, is there a real risk the jury was influenced against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that the court had been a widespread attempt to bribe the jury and then